Okay, class, this is your second mock final. Let me give you 1 minute at 180 for practice, okay? Warm-up practice. Make sure you speed build before this one, okay? Here we go, 180. Mr. Speaker, I am very pleased today to introduce a bill to revise the Employment Economic Opportunity Act. My distinguished colleague and friend, Senator Nathaniel Bryan of New Hampshire, is the current chairman of the Committee to Develop Employment Opportunities. I am also a member of this committee. This bill would make important modifications to the Job Development Program and the Youth Employment Program. This bill would also authorize the establishment of bilingual educational programs for minority groups. Mr. Speaker, I have had a long personal involvement in and identification with our nation's war on poverty. Since 1969, I have worked on committees with 4 former presidents, Mr. Johnson, Mr. Nixon, Mr. Carter, and Mr. Reagan. The strategy that has always been used is to try and break the vicious cycle of poverty that is a hopeless web for many Americans. Like so many other problems that Congress must face, the problem of poverty is one that can only be broken with determination and a firm commitment to freeing the poor of America from discrimination, unemployment, and dependency. And we have on your 180 lit proper names, you have Mr. Fulmer, Mr. Kenser, Mr. Earl Kenser, GPA, All-American, Anita Martin, Anita and Earl Kenser. And this is going to be 180 lit for 5 minutes for your mock. I thank you, ladies and gentlemen, for your attention to this matter. We have heard some most unusual remarks today from Mr. Fulmer, and at this time it is appropriate that I now give you some answers, if I can, to some of the remarks he has made. To my thinking, what you have to understand is that Mr. Fulmer is trying his best to put a certain image of this man in your minds. He wants you to begin to think about him in a certain way. He goes about this by trying to get you to see this man in a new and different light than you have yet to see him in. He talked to you about wanting to bring a 10-year-old boy into the courtroom so that you could witness for yourselves how fond the children were of this young man. He wanted the boy to explain how all the kids at school liked him. Well, we aren't saying that they didn't like him. We aren't saying that at all. As a matter of fact, all these people that Mr. Fulmer brought in here have said that they all thought of him as just a regular guy, a nice guy, and not one of them felt differently. Not one of them felt that Mr. Kenser had a dark side. Not one of them felt that he was abnormal in any sense of the word. In fact, it was established quite early on in this case that Mr. Earl Kenser is the kind of guy that no one would ever suspect of harboring an abnormality, of not being entirely normal. Mr. Fulmer talked quite a bit about how well Mr. Kenser did at college and how he did so well that he graduated with honors. He apparently had a very impressive GPA and was active in several campus clubs. He graduated with honors. Mr. Fulmer talked quite a bit about how proud his parents were of him. I wonder how proud his parents are of him now. What do they think of their son now after what he has done? Mr. Fulmer goes on and on about this young man, and he tries to paint a picture of an all-American boy for you. He really wants you to see him that way. This image of him, ladies and gentlemen, this attempt by his attorney to make him look like your normal, upstanding citizen is not an honest portrayal of Mr. Earl Kenser. This man who killed Anita Martin in such a brutal fashion is not normal. He is not your normal all-American boy. His conduct was antisocial and abnormally brutal. He wanted to get rid of Anita, and so he did. She was the one person that he wanted to be rid of, and he told us that himself, remember? He told us that from the witness stand. He told us that from May up until December that he wanted her out of his life. He wanted her gone. Mr. Fulmer also told you, ladies and gentlemen, that the location where the murder took place was not secluded. Well, I submit to you that when you go down into the area, you will see that it is very secluded after all, and that it leads down to a small beach that is not in use in the winter months. No one is down there. No one ever goes there in the winter. And Mr. Kinzer knew all about that. He grew up in the neighborhood of that beach, ladies and gentlemen, and he knew how secluded it was there in the winter. He took Anita Martin there with the intention of killing her. She tried to get out of the car. She tried to get away from him at one point by jumping out of the car they were in. But he was too quick for her. He pulled her back into the car, and that is when he decided he was going to kill her. He needed to silence her, and he did. He talks about the pictures in his head of how he was going to do it. He had obviously put a lot of thought into it already. He had thought about this before he ever met Anita Martin. He had thought about it before he ever had her in his car. Remember, ladies and gentlemen, that the thought of killing had gone through his mind before. It was on his mind a lot, and he was intrigued by the thought. Earl Kinzer thought he could commit the perfect crime. He had never killed anyone before this fatal night, and it went through his mind that he was going to commit a perfect crime. The problem with that concept of perfection, though, is that it rarely pans out. And that night, he left his glasses right there at the scene. Now, Mr. Fulmer would like you to believe that it was an accident. He would like you to believe that Mr. Kinzer wanted to get caught because he knew in his heart that what he did was wrong. But the truth is, Mr. Kinzer had thought about killing for a long time, and the evidence shows, as you will recall, that he had plenty of time to come up with this evil plan. Mr. Fulmer told you that and then we have 1 minute at 200 jury charge for practice, okay? The jury has retired. In response to the question from the foreman and considering the definition of assault with intent to commit murder, we will clarify wrongful act and attempt was unlawful. I'm going to read to you the legislative definition of assault from the Penal Code. The Bar Review Committee has included some other words that probably created some of this confusion. Assault is an unlawful attempt coupled with a present ability to commit a violent injury upon the person of another. You can see in the printed instructions that were submitted to the jury and are made available to the jury through their deliberations, we have added, to commit a wrongful act by means of physical force instead of to commit a violent injury. When you have an assault, what it really means is that you intend to strike, hit, shoot, or knife another person. In other words, you intend to commit a battery. I am not getting too historical or academic in my next comment, hopefully, but one of the cases that most law students read, at least I read it back in the late 60s when I was attending law school, is a case from, and then we have on your 200 jury charge proper names. It says none, okay? This is 200 jury charge for 5 minutes. And I see court, capitalized court, when you can replace judge in the sentence. Members of the jury, I will instruct you on this civil case at the beginning of the trial and again at the end. I believe it to be helpful in focusing the jury on their duties early on and in giving them a basic understanding of why certain evidence and testimony will be presented to them. So right before the opening statements are given, I will instruct the jury on their function and duties as well as the duties of the attorneys and the court, and I will cover other certain areas of the law that I feel are important for the jury to be aware of at the beginning of the trial. At the end of the trial, I will repeat the applicable law of the case and any other instructions that I or the attorneys feel should be repeated. The standard jury instructions in a medical malpractice case will be given at the beginning of the trial unless they are inapplicable to the case. Members of the jury, this is a malpractice suit against a doctor and a hospital. Before any medical malpractice case can be submitted to the jury, the plaintiff must first prove the elements of their case with evidence of both negligence and causation. These elements are based on a jury instructions which define the law that applies to medical malpractice. A physician is negligent if he or she fails to exercise the level of skill, knowledge, and care in diagnosis and treatment of a patient that other reasonably careful medical practitioners would possess and use in the same or similar circumstances. You are to base your decision in the case only on the expert witnesses and on the defendant's testimony. The plaintiff must prove to you by a preponderance of the evidence that the defendant's actions were not reasonably careful in relation to other physicians in the same or similar circumstances. The focus, ladies and gentlemen, is on the actions or lack of actions of the defendant doctor in this case, and not on her thoughts or what she was thinking at the time. You will keep your focus on her actions rather than her thoughts, and that will provide for a more objective evaluation. This instruction, by the way, which defines the duty of a physician, has the same language and duty for a nurse. It is the actions of a doctor or a nurse in any given medical situation that must be reasonably careful rather than the reasons for their actions, which form the definition of negligence. Regarding the jury instruction on alternative methods of care, a doctor or a nurse are not necessarily negligent if, in exercising his or her own best judgment, he or she selects one of the approved methods of care, and it turns out that another accepted method would have been a better choice for the patient at the time. A hospital is also negligent, ladies and gentlemen, if it does not use reasonable care toward its patients. It is the law that a hospital provide qualified personnel for the treatment of its patients. All hospitals are required under the law to have written policies and procedures in place, and the failure of any person on a hospital staff to comply with the written policies and procedures can be used as evidence on the issue of negligence. Causation is at issue here too, ladies and gentlemen. A substantial factor in causing harm is a factor that a reasonable person would consider to have contributed to the harm. It must be more than a remote or trivial factor. It does not have to be the only cause of the harm. In other words, as against the hospital, in this case, the plaintiff alleges that it committed malpractice also through the actions of its doctors. A hospital itself may be liable for the negligence of its staff if they have violated the legal standards of negligence that apply to them. In determining whether or not the hospital violated the standard of care, you may consider whether their own written rules and policies were violated. Hospitals are bound to exercise the amount of care toward a patient that the patient's condition requires. Injury alone does not raise a presumption of the hospital's negligence. Due to the nature of this case, the witnesses who will take the stand and testify will be what is known as expert witnesses. As defined by the law, experts are people who, due to their education, experience, training, or otherwise, have special knowledge which is not held by most people in general. Experts may state their opinions on matters in their field of knowledge and may also state the reasons they have that opinion. The testimony that an expert gives should be judged in the same manner as the testimony of any witness. You may accept or reject the testimony of an expert witness in whole or in part. You may give the testimony of an expert witness as much weight as you think it deserves as you consider all of the facts and evidence in this case. If you should decide that the opinion of an expert witness is not based upon sufficient education and experience, or if you should decide that the reasons given in support of the opinion are not sound, or if you feel that it is outweighed by other evidence, you may disregard the opinion. All that I have already explained to you about impeachment of witnesses also applies to expert witnesses. If you should find that an expert's testimony is less than credible, you may disregard it. In general, the opinion of an expert has value only when you accept the facts on which it is based. This is true whether the facts are posed to the expert witness as a hypothetical question or not. Questions will be asked of the expert witnesses that invite them to assume that certain facts are true and to give their opinions based on and then we'll get ready for your Q&A. And this will be 1 minute warm-up Q&A before your Q&A for the mock. Sherry, what is your full name?
Sherry Lynn Harbin.
Now, Sherry, are you nervous today a little bit?
Yes, sir.
Well, just calm down now. We want you to testify as best you can.
Yes, sir.
Sherry, how old are you?
13.
All right, now who is your father?
Robert Dean Harvin Sr.
What about your mother?
Sandra K. Harvin.
Now, do you go to school?
Yes, sir.
Which school do you go to?
Lauren Road Middle School.
Sherry, you understand what this proceeding is about today, don't you?
Yes, sir.
Now, do you understand the difference between right and wrong?
Yes, sir.
You know what lying means?
Yes, sir.
You know what telling the truth means?
Yes, sir.
All right, now you know that when you take the oath here today that you are supposed to tell the truth.
Yes, sir.
Nothing but the truth.
Yes, sir.
All right, let me call your attention, Sherry, if I could, to the evening of July 21, 1974. That was the summer in the evening of July 21, 1974, about 2 years ago. You remember that night?
Yes, sir.
I want you to tell, as best you can in your own words, I want you to tell the truth. And if there is something that you don't know, don't try to answer it. Okay, so you have on your 225 proper names, Jack, Mr. Martin, Cumberland, 11th, Tim, and Mr. Barn. And this is going to be 225 Q&A, you all. It does start in the middle for 5 minutes. Jack, I'm going to ask you some questions, and I want you to look at the jury when you answer them, okay? They have to judge your testimony, and I want you to direct yourself to them. Do you understand those instructions, Jack?
Yes.
I know you're a little nervous, but Jack, how old are you?
16.
And at the time of this incident, Jack, how old were you?
15.
Now, Jack, I'm looking at you now. You have some facial hair. Did you have any facial hair at the time of this incident?
Not as much. It was a little bit.
Just a little?
Just a little peach fuzz. I've been locked up and it gets to you.
Jack, you were found guilty of a burglary as an adult. Did you commit that burglary?
Yeah, that's why I was found guilty. But I didn't do this.
You didn't do this.
No.
And that's why you chose to plead not guilty. Is that correct?
Yes.
Jack, on the day of this incident, did you meet up with Mr. Martin,
Yeah.
the hack driver?
Yeah.
And what happened when you met with him that day?
He took me around. I told him to take me up to the 11th and Cumberland. But first I said, take me around the corner.
When you met Mr. Martin, were you with anybody?
No, I was by myself.
And you asked Mr. Martin to take you around the corner. Is that what you're saying?
Yes.
And did he?
Yes.
When he took you around the corner, what happened then?
Somebody got in the car.
Somebody got in the car. Is that person here today?
No.
What's that person's name, if you know?
Tim. I don't know his last name.
Had you and Tim had any discussion or any conversation about him getting into that cab at that time?
He said he wanted to go down to the projects with me, so he got in the car.
Where were you sitting in the car when Mr. Martin picked you up?
Front seat.
Did you have any money in your pocket, Jack, to pay him?
Yeah, I always have money.
How much money did you have in your pocket?
Like $100.
$100?
Yeah.
And how far was it from where he picked you up to where you were going to go? You said 11th and Cumberland?
That's like about 1.5 miles.
Did you have any agreement with the hack driver as to how much you were going to pay him?
He didn't say nothing about no pay. He was just like, come on, get in.
Now, Mr. Barr got into the car, correct?
Yes.
And then what happened?
Drove up to the supermarket.
And that's the supermarket that Mr. Martin told us about, right?
Yes.
And when you got up to that supermarket, what did you do?
I got out of the car.
And where were you going, if anywhere?
I went to the market.
You went into the market.
Yeah.
Did you buy anything in the market?
Soda.
Where was Mr. Barr when you went into that market, Jack?
He was still in the car.
He was still in the car.
Yeah.
Now, after you bought your soda, did you come out of that store?
Yes.
And then what did you do, Jack?
I came up to the car and Tim had a gun to his head.
Tim had a gun to whose head?
The complainant, Martin.
Was that the first time you had seen that gun?
Yes.
And when you saw this gun to Mr. Martin's head, what did you do?
Just stood there. I wasn't going to do nothing.
You just stood there?
Yeah.
You heard Mr. Martin, he said that you got out of the car and you were looking towards the store. Do you remember that?
I walked away from him because I didn't want to be involved.
So when he said that you were 8 or 10 feet in front of the car, looking back and forth, do you remember that happening?
I was about 8 or 10 feet, but I wasn't looking back and forth. I was just standing there.
So that 8 or 10 feet was after you had gone into the store. Is that what you're talking about?
Yes, after I walked away from the car.
Is that where you saw Tim Barr with the gun on Mr. Martin's head?
Yes.
Now, did you get back into the car?
Not right then and there.
What happened?
He made me get out the car.
He being who?
Tim.
And?
Still had the gun to him and took the keys out of the ignition, and then the dude walked. Martin walked around and he slid out. He still had the gun to him.
Jack, were you scared at this time?
Somewhat. I didn't know what was going through his head. He had a gun to him. I didn't know what he was going to do to me. So I just, man.
Now, did you get back into the car at some point, Jack?
Yeah,
Why did you get back into the car?
because I didn't know what was going through his head.
But you got back into the car, didn't you, Jack?
Yeah,
And what happened when you got back into the car? Who was driving, by the way?
Tim.
And what happened when you got back into the car?
He just drove around and that's about it. He was running into stuff.
How did you feel when you were driving around in that car?
I'm thinking he sees me here with him. If I try running, what he's going to do to me. That's what I was worried about. I wasn't worried about him in the trunk. I was worried about myself.
Now, you heard Mr. Martin tell us that there was conversations or talking in the car where there was something about Mr. Martin's brains are going to be blown out and all that. Did you have any of that conversation?
No. What Tim said was, he said, let's go to the bridge and make him jump in the river. I said, you let me out. I don't want to have nothing to do with that. He said, no, you're involved with us. So we all won't go now. We all are here now, so we just won't go. But we ain't never went to the river to do all that.
So at some point, Jack, you got out of that car, didn't you?
Yes.
When you got out of that car, what did you do when you got out of that car?
Started walking away.
Started walking? Okay, well, that's your last test. Good luck. Type it up. See how you did. And check your Blackboard messages. I'll be sending you information, okay? Have a great break.